When a state grants itself unchecked administrative power, the system becomes highly volatile. It removes the friction of due process, letting the executive branch act with sudden, overwhelming force. To understand the mechanics of this risk, we can examine a theoretical stress test, the fictional FCRA Amendment Bill 2026. The proposed legislation contains a controversial mechanism. It allows the state to seize a non-governmental organization's assets immediately upon registration lapse, bypassing prior judicial review. The government maintains that this level of authority is a necessary defense mechanism. They argue closing regulatory loopholes is essential to eliminate foreign funding misuse and protect national security. Civil society organizations view the exact same mechanism as a weapon. They argue it creates a framework for executive overreach, giving the state a tool to suppress legitimate organizations over minor infractions. The fulcrum of this entire mechanism is a new role called the designated authority. This creates a bureaucratic choke point where a single civil servant holds absolute discretionary power over an organization's continued existence. A law's theoretical validity on paper does not guarantee its ethical application in reality. The text of a statute is static. It requires human interpretation to bridge the gap between regulatory intent and actual justice. We can test this dynamic by placing a hypothetical protagonist in the center of the mechanism, Undersecretary Deepak Sharma, newly appointed as a designated authority. The first file on his desk belongs to a small NGO called the Asha Foundation. For 15 years, the foundation has operated without interruption, running free health and nutrition camps in remote tribal areas. Their current renewal is pending. The delay is purely procedural, a matter of late paperwork. There is zero evidence of corruption and no allegation of misused funds. The collateral damage of strictly executing the law is immediate. If Sharma orders asset seizure, 3,000 vulnerable tribal families instantly lose their only healthcare access. Complicating this is an intense institutional pressure. Senior officials in the Ministry of Home Affairs have explicitly instructed Sharma to use this first case to set a strict example, proving the law's authority. Sharma has exactly 7 days to deliver a final, binding decision. Viewing this as a choice between obedience and rebellion oversimplifies the stakes. It is a complex administrative engineering problem, requiring formal ethical frameworks to resolve. To remove subjective bias and gut feelings from the equation, we can map Sharma's choices using a systematic decision tree matrix, starting here with our administrator in the center. The first branch is option 1, strict compliance. Sharma could seize the hospital and school immediately, appeasing his superiors and following the absolute letter of the law. But this action immediately collides with the first filter, proportionality. The proportionality axiom dictates that the severity of an administrative response must match the gravity of the offense. Totally destroying a functional institution over a minor paperwork error fails this test of proportional action. If the action attempts to bypass proportionality, it hits a second philosophical barrier, John Stuart Mill's harm principle. Mill's core rule posits that state power is only justified when it is deployed to prevent actual, material harm to others. Applying this to the Asha Foundation, a procedural delay in form filling causes zero material harm to the public or the state. Therefore, deploying the state's most severe punitive measure is unjustified. Option 1 fails the algorithm. A mechanistic execution of the law might satisfy institutional pressure, but it violates foundational administrative ethics and creates a systemic injustice. The second branch is option 2, administrative avoidance. Sharma simply ignores the file or indefinitely delays the decision. The psychological appeal of this choice is obvious. It temporarily protects the NGO's operations, while allowing Sharma to avoid a direct confrontation with his superiors. But this path immediately collides with the filter of regulatory accountability. Evading a decision undermines the rule of law. It leaves the regulatory system stagnant and vulnerable to future arbitrary misuse by other officers, who might weaponize the same delay tactics. Option 2 fails. Inaction offers no moral high ground. It is an abdication of an administrator's duty to govern. The third branch is option 3, procedural equity. Sharma grants a strict, time-bound grace period for the renewal, ensures the hospital services are not disrupted, and formally documents his entire decision process. This path approaches our first historical filter. Aristotle's concept of epieikeia, or equity. Aristotle argued that broad, generalized laws are structurally incapable of accounting for every specific, benign anomaly that occurs in reality. Equity demands that an administrator apply the spirit of the law, in this case protecting national security, rather than strictly enforcing a punitive, literal interpretation that misses the actual target. The path then reaches our second filter, Mahatma Gandhi's principle of trusteeship, expanded for modern public administration. Trusteeship dictates that executive power is a resource held in trust for the welfare of the public. It cannot be used as an instrument for institutional flexing. The final filter is legal precedent, specifically the Supreme Court of India's ruling in the case of Noel Harper versus Union of India. The court ruled that while organizations do not possess a fundamental right to receive foreign funds, state regulation cannot be applied in a way that unjustly terminates an organization's right to exist. Option 3 is the only optimal path. It neutralizes the dilemma by fulfilling the state's legitimate regulatory mandate to monitor funds, while legally and morally protecting the innocent and beneficiaries relying on the NGO. Making the ethical choice in theory is straightforward. Executing it safely in reality, while actively defying direct pressure from the Ministry of Home Affairs, carries significant career risk. The formal, written file note serves as a civil servant's primary defense in this environment. Sharma must explicitly record his exact rationale on the official record. He must detail the lack of any security threat, note the purely procedural nature of the delay, and meticulously log the specific instructions to make an example of the foundation. This act of total transparency functions as an administrative shield. By forcing off-the-record institutional pressure into the light of legal scrutiny, it neutralizes arbitrary demands. Within a bureaucracy, moral courage has no value unless translated into documented, reviewable procedure. A structurally just government cannot rely exclusively on the rare heroism or philosophical rigor of individual officers, like Deepak Sharma. This blueprint is the institutional safeguards engine. It illustrates why the fictional FCRA Amendment Bill requires built-in mechanisms to govern its power safely. The first necessary pillar is mandatory judicial review prior to any extreme administrative action, like asset seizure. The second pillar requires formal proportionality checklists. These strip away absolute discretion, providing a framework to objectively differentiate between minor clerical errors and severe security threats. The third and fourth pillars are statutorily mandated grace periods for purely procedural delays and independent oversight panels assigned to monitor the designated authority's decisions. Together, these four safeguards act as physical dozeners on the engine of state power, preventing the executive branch from revving into overreach. Administrative rigor requires tethering the state's immense power to ethical frameworks, ensuring the rulebook serves the pursuit of justice.